So, good evening, everyone. This is Ashwani, and on behalf of Criminal Review team, I welcome you all to this webinar on procedural difficulties at trial courts and their impact on criminal justice. We have with us Dr. Advocate Nipun Saxena as the guest speaker for today's webinar. Mr. Saxena is a graduate of National Law University, Delhi. He graduated in 2014 and has been practicing since then. He appears before the Supreme Court and various high courts across India. He also appears before tribunals and quasi-judicial authorities. He has authored and contributed to various reputed international and national publications. He was also associated with the Additional Solicitor General of India and worked extensively on various landmark judgments. His interest lies in the areas of constitutional law, criminal law, civil and criminal procedure, property and real estate law, white-collar crimes, among others. Without taking much time, I invite Mr. Saxena to initiate the session and also thank him for taking out his time for the webinar. So over to you.
Thank you so much, Ashwani, for a very generous introduction. First of all, I must apologize to everybody. There was some delay at my end. There was an electric failure, because of which I couldn't join in time. Right. So now the topic that we have chosen for today, that I've been asked to speak about and share my views, is procedural difficulties, and as a consequence of which there's a denial of access to justice. The first thing that comes to my mind is to have it arranged in a schematic basis, right? So what I will do is I will first try to talk about the delays that occasion the procedural delays, which is prior to the filing of charge sheet. Second is what happens during the course of the trial, and third is certain appellate remedies, which of course best intended also result into certain procedural delays, and other miscellaneous things which I think are very crucial. So let's first start with investigation and prosecution. What happens is that India follows the British model, where the police has sovereign right to investigate an offence. Now, of course, the first problem begins right there, which is an information is received and that information has to be reduced into writing. The mandate of law is not to carry out any preliminary inquiry. If the information discloses the commission of a cognizable offense, the information has to be reduced in writing and 6 copies thereof have to be made. A prior intimation has to be sent to the concerned magistrate, area magistrate, and subject to whatever other procedural formalities are contained in various police acts or police rules or manuals of the specific state, the bare minimum which has to be followed is this. Now, what happens is when information is received, it is not immediately reduced into writing so as to constitute an FIR. It is, of course, registered in some or the other forms. Let's say there's a complaint which is received, a general diary entry is made, but the same is not always instantaneously reduced into writing. And therefore, the procedural delay starts at that instance. Because a person who wishes to get her or his FIR register will have to travel from pillar to post. Of course, there are safeguards embedded within CRPC, which is, let's say, a refusal of a police officer to register an FIR will entail a step 1, which is you write an application to the Superintendent of Police under Section 154 subclause 3. And even if, let's say, the Superintendent of Police does not direct or fails to direct the concerned IO or SHO to ensure that an FIR is registered, a further remedy lies by way of a Section 156 subclause 3 CRPC application or a complaint under Section 200 CRPC. And in many cases, I have seen people file writ petitions, right? All of this will take time. So this is fatal to the prosecution case itself, delay in registration of FIR. Despite various reminders by the Supreme Court in so many judgments, the police still does not register an FIR promptly. Prompt registration of an FIR will ensure that 25% of the work is done right there and then. But what happens is that the police insists on carrying out a preliminary inquiry, which is why the problem begins, right? Now, of course, all of us would recollect, those of us who are practicing criminal law would know that Lalita Kumari versus State of Uttar Pradesh was that very landmark decision, which if I remember, 2014 2 SCC page 1, yeah, it clearly says that if there is an information, the police officer has no other option but to record it immediately. But that seldom happens, despite the Lalita Kumari precedent being there. Which brings me to another aspect. Now you are recording statements under, say, section 161 and 164. I have seen a very new trend amongst those cases where closure reports are supposed to be. Even where a closure report is filed under section 169 of CRPC, the law requires the individual satisfaction of the investigating officer that even after conducting investigation, no commission of a cognizable offense was disclosed, and therefore you are filing what you call a closure report against X person. Now, what happens is, the requirement of law is it has to be the individual satisfaction of the investigating officer, and that individual satisfaction requires no further judicial scrutiny. All that he has to do is file that closure report and place it before the court. Now, the court will then take a decision whether to A, take cognizance, B, accept the closure report, or C, order further investigation. That is the domain of the court. Now, in many cases, what I have seen is that the court now proceeds to conduct its own inquiry and proceeds to record statements under section 169 CRPC, which is nowhere mandated under the CRPC. In fact, this is a procedure which is unknown to CRPC. The problem is that on one hand, the theme of CRPC postulates that the police is sovereign and the right to investigate is sovereign. And therefore, if the police has ventured to investigate, the decision to investigate, what to investigate, under which provisions to investigate, solely and exclusively lies with the police officer. The court cannot tell you how to investigate and what to investigate. Even in a court-monitored investigation, the court can't ask you all these questions, those specificities, because it tramples upon the right to investigate, the sovereign right to investigate, and all of that has been held from the times of Khwaja Nazir Ahmad by the Privy Council decision, followed by Abhinandan Jha and so many line of cases. Now, in rape cases, for example, you will have multiplicity of statements. You will first record, which is by you, I mean the IO will first record a statement under 161 CRPC. Then he will take the prosecutrix to the magistrate to record her 164 statement. And thereafter, during trial, she has to again record her statements. I think that multiplicity of statements is something which is deeply problematic, because what happens is, from the time an initial statement is recorded under 161 to the time that the trial actually takes place, there's a considerable delay or lapse of time, and therefore the memory does not remain fresh. There may be certain minor variants or minor problems in understanding or saying whatever it is, right? And therefore that becomes a tool at the hands of the defense counsel to exploit it. Say that there are material contradictions, alterations, improvements, sure, but one should realize that the law also says that that you have to give some you must have some countenance for memory lapses or any of those things. But these multiplicity of statements being recorded further creates a problem, right? Specifically in sexual assault cases. The prosecutrix is made to relive the trauma over and over and over again. Second, she is made to travel from pillar to post. She has to first be taken to a police thana where her 161 is recorded. She is thereafter taken to a magistrate's residence or a court to record a 164 statement. And thereafter, of course, she has to also appear before the courts at various points of time. Right. So I think that multiplicity of statements must be done away with. One statement under section 164 CRPC and one statement during trial is more than sufficient to see whether the testimony holds good or not. Right. Now there is another problem which I find is this fascination with filing bulky charge sheets by the enforcement agency. It is widely speculated and widely believed that the more the number of pages of a charge sheet, the better would be the conviction, right? And therefore, the police will go 20 steps ahead and even incorporate so many witnesses which are not even necessary for the purpose of conducting a trial, right? The same number of witnesses who are saying the same thing over and over and over again, right? Or statements of witnesses who have nothing whatsoever to do with criminal, with the trial, and yet their names have been incorporated so as to show that look here, look at the extent of investigation done by us. I think that practice must be severely deprecated. I am shocked to see very high profile cases having so many pages in charge sheet which run into thousands, sometimes several thousands of pages, which makes the job very difficult. Because what happens is, it is done with the intent to preempt the possibility of the accused to file a quashing of the charge sheet or to file a discharge application. Because if you put more the number of files, etc., it takes time for anybody, any court or any judicial authority to view it, right? And therefore it effectively also, if not take away, but it quite in many cases it sort of makes the defense counsel's job much more of an uphill task, right? And the fact that it is so voluminous and and at the same time it is so unnecessary makes it even more daunting task to be defended during a trial, right? To my mind, these are some of the problems that happen at the pre charge sheet stage. One more thing which happens is to constantly file supplementary charge sheets. Now, under section 167 CRPC, if a police officer fails to file charge sheet within a period of say 90 days for a heinous offense and 60 days for an offense which is not heinous in nature, the person is entitled to what you call statutory bail or default bail. That the police officer has failed to submit their charge sheet within a period of 90 days, therefore the person gets a right to secure bail. Now look at how exactly this process is sort of misused. On the 89th day, the police officer concerned will file what you call a supplementary charge sheet. They will knowingly keep 2 or 3 documents with them with the intent to file them at a later point of time, so as to build a better case, a stronger case, or to establish a wider nexus or a bigger conspiracy theory that there is an entire racket, there's a ring, there is a cabal, and all those fascinating terms that the prosecuting agencies love to use, right, are all pressed into service. And I think that creates a lot of trouble for both for effective trial to take place. Because if you don't file your charge sheet in time, the trial cannot commence unless and until you either file your closure or your charge sheet or whatever it is. Now, I understand that in many cases it is not possible for the police to carry all of these functions within a period of 90 days. I understand and I'm alive to that proposition. But what usually happens is that is the reason that I see is because the police is saddled with too many works. investigation must be separated from maintenance of law and order. And maintenance of law and order must be separated from, let's say, other miscellaneous tasks such as election duties, providing security to ministers, etc., or VVIPs. I think all these four tasks have been kept on the shoulders of the police, and therefore I believe that the police does not get enough time to investigate. I also think that non-digitization of police records is a very, very big impediment, because what happens is, let's say the court calls for an action taken report or a status report on the status of investigation. Somebody moves a 156 thing, right? Uh, it takes days or sometimes even months to file one status report. In one of the matters that I was doing, I was shocked to find that one status report took 2.5 years. And because of that status report taking 2.5 years, the trial could not commence. And this was a pretty serious trial. This was a murder case. Now, in on account of all these things, I think these are all procedural deformities because of which the trial itself cannot come. Now, let's assume that everything goes fine. Charge sheet is filed within a period of 90 days. The person is arrested. The person, the offense, the information also discloses the commission of a cognizable offense. And finally, the charge sheet is placed before the court for its acceptance, rejection, or a direction to further investigate. Now, this is where another set of problems begin. If the court is convinced that yes, cognizance can be taken, the court issues what you call summons, or if it's a heinous offense, or if the court feels that through summons the possibility of enforcement of presence cannot be made out, then of course warrants are issued. But there is an unwritten rule which at least a couple of courts, district courts, do take into account. That unwritten rule is send them summons. If summons are returned unserved, send them again twice. Then you send them bailable warrants. You do that twice. Then you send them non-bailable warrants twice. And only thereafter initiate proceedings under Section 81 to declare the person as a proclaimed person or a proclaimed offender, depending on how heinous the crime is. Imagine 7 dates have gone by only declaring the person, a proclaimed person or a proclaimed offender. And this is the case of an accused person. Now, let's say a person is in custody, then he, of course, there's no requirement of sending a summon or a warrant. He will be produced before the court at every date of the trial. Imagine a situation where you have to follow the same process for enforcing the presence of a witness. That becomes difficult. Now, if you have named 20 witnesses or 30 witnesses, you have to again follow the entire process. And what happens in this process is that first, an officer of the court will usually give it to one of the police liaising officers who is deputed with every court. That police liaising officer will give it to, will call the person, or will call the police officer from the concerned thana to give the copy of the summon. The person in the police will then go and effectuate delivery of the summons or execute those summons on the person who is to be called as a witness. If he appears, if he does not appear, the report has to follow the same steps by using those people to come back to the court, right? And all of that takes into account tremendous wastage of manpower, tremendous wastage of resources, and tremendous wastage of precious judicial time. Now, of course, the Honorable Supreme Court of India and the Delhi High Court have passed various directions to the effect which say that you don't require to carry out all these exercises. All that you can do is you can deliver summons on directly on the contact number or on instant messaging apps such as WhatsApp, Telegram, Signal, or whatever, or you can also email them. So long as service is effectuated, it will be deemed to have been have been served upon the person. Now that I think is a very, very good step, but that step must be replicated throughout for both civil proceedings as well as criminal proceedings. The person does not have to go find the actual residential address, etc. And I think there's another problem with it. Sometimes what happens is that the witnesses do happen to change addresses. Now, if you do happen to change addresses, then you must at least intimate or inform the police officer that this is my new address, so that the poor person does not have to run and try to chase you and find you somewhere in this country. Because that is precisely what has been happening in many criminal trials. Right? Now, which brings me to another aspect, which is the role of prosecutor. Now, the scheme of CRPC suggests that prosecution job starts when the trial commences or not, and not before. My suggestion would be that once a dedicated investigation agency, and I'm not just saying police, once a dedicated investigation agency submits a charge sheet, that charge sheet must first be placed before the district prosecuting officer or public prosecutor. And that public prosecutor or district prosecuting officer must look at the charge sheet, find out whether actually an offense is made out or not, and only then place it before the court. Otherwise, the power to carry out more investigation or further investigation must be conferred on the prosecutor. Once that is done, it would solve a lot of time doing back and forth with within or inside the court, because all these processes can happen outside the court also. The charge sheet can only be filed once the prosecuting officer or the district prosecuting officer or the public prosecutor is satisfied that yes, offense is made out, and yes, prima facie it appears that this person has committed the offense. That of course seldom happens, but this is one change that I would suggest from my end. Right now, during the course of trial, you have what you call a faulty way in which evidence is collected. So, for example, ballistic report. For example, voice analysis report. Many a times, the requirement of the forensic examination agencies is that you collect ample evidence, ample sample, so that that sample can be examined properly. Now, audio recordings of less than a minute are sent to find out whether those were genuine or not. Many a times, while copying the contents of the file from one file to another, there's a lot of contamination that happens. You don't do it properly, or for whatever reason, the sample gets contaminated, because of which, in many cases, the forensics examination reports are inconclusive. And since they are inconclusive, it becomes all the more difficult for a trial to proceed in the manner. In fact, what happens is that the trial has to discard that forensic report for which the trial court was waiting for as long as maybe 8 months, 9 months, 10 months. Now, where offenses of serious nature, say lokayukt offenses involving corruption, offenses involving economic offenses, the officers must be trained how to properly collect evidence. And since that is not happening, I think that leads to a lot of procedural delays. Now, what also happens is that the law stipulates that there has to be a mobile forensic examination unit in every district. Regrettably, that is not the case. Many times, let's say an offense has taken place in one remote district in Chhattisgarh, it will have to go to Bilaspur, or it will have to go to Raipur, because the central forensic science lab is situated there. In fact, many a times what happens is that samples are sent to established and reputed laboratories in Chandigarh and Hyderabad. Say for a trial which is happening in, say, a district, say Guna in Madhya Pradesh, and the FSL examination reports are going to Chandigarh or Hyderabad, it will take its own sweet time to come. And that too, it has to come through that proper formal channel. And all of that takes time. And because of that, the courts are left with no other option but to adjourn the matter. Many a times what they would say is, all right, we'll try to get the witnesses examined. But But more often than not, what usually happens is that these reports, etc., take their own sweet time to arrive. And in many cases, the court has to pass a judgment because it does not have the benefit of that expert opinion on the basis of which other expert witnesses could be examined. Whether they were saying truth or whether they were saying something false, the veracity and accuracy, authenticity of all of that could be established once you have the report. Without the report, there's nothing that you can do. And there are so many cases in which judgment is passed first and then the report arrives after 2 months or 3 months of the judgment being rendered. And all of that, of course, may give you a good ground for appeal, but it takes away that precious judicial time, and it also sort of is antithetical to the idea of a fair trial. Now, there's another thing which is what you call the day-to-day of recording of evidence. That is almost never followed. Even in very serious cases such as sexual assault cases, rape cases, there are dedicated fast track courts. But what usually happens is that please don't misconstrue what fast track court is. Fast track court does not mean you will have a new building, a new judge sitting in that building with all high tech, state of the art infrastructure. That's seldom the case in very many districts of India. I'm not talking about the cosmopolitan courts of Saket district court or Dwarka or one of those courts, or in Mumbai city courts. I'm talking about so many districts which have to share the same building for many purposes. So let's say from 10 a.m. to 11 a.m. or 10 a.m. to 1 p.m. There would be regular court, and the fast track court will sit at 1:30 p.m. only about 2 p.m. after lunch to 4 p.m. So in effect, your fast track court is sitting every day, but the amount of judicial time that it's getting is only 2 hours every day. And there you expect them to carry out a day-to-day evidence recording. And evidence recording in very sensitive sexual assault cases or say terrorist cases takes a lot of time. It's not that one person will come, they will depose. Sometimes testimonies go on for 20 days and 30 days. And here comes the problem. The recording of evidence of witnesses, specifically police officers who are IO, leads to a lot of issue. Say there is an election duty because of which the IO cannot come. Next day there was some riot that had broken down. IO couldn't come. Third, there's some VVIP movement. The IO couldn't come. Right? Fourth, the IO was transferred. I have seen a criminal trial where the trial went on for years, and at that point of time, there were 4 different IOs who were appointed at various points of time. And now all those 4 different IOs were situated at different districts. So for every date of hearing, the IO had to, poor chap had to travel, depose, and go back. And all of that eats up into the judicial time because either you have to wait it out or you have to conduct those kind of you have to wait it out or you have to issue summons to them repeatedly requesting for their presence. Now, the way out is, and thanks to the technological interface that is now available to us during COVID times, which is um, access to video conferencing and recording of statements through video conferencing mode. I think that has become very, very easy, efficacious, and effective while recording evidence. And I think one of the magistrates of Delhi court has started this uh, exercise of recording evidence through virtual means. And I'm sure and I hope and pray that many courts follow suit. And of course, it's not as good as physically recording of evidence, but it is really very good. And it is something that could be replicated. Of course, it comes with its own set of troubles. Everybody is alive to the proposition that a person may try to willfully disrupt the network, at which point of time the judge can enforce their appearance personally and physically. But that does not mean that the general practice of allowing recording of evidence through virtual media must be discarded or discontinued. I think that would be a real game changer with that kind of a tech interface in the mode and manner in which evidence is recorded. Now, what I also see is another very crucial aspect where which becomes a subject matter of delay, which is filing of revision petition. Usually, what happens is that the exercise of in exercise of powers under section 397 and 401, the court usually, the superior court would call for records of the court which is inferior, which is usually the trial court. Now, while the superior court is examining, the original records have gone to the superior court, and therefore the trial is rendered, it's that is adjourned sine die until the records first come back to the trial court. Because without the files or without the papers, judges cannot proceed with the case. So many a times that exercise takes years together, because of which the trial, even though there is no stay on the trial is practically stayed. So this gives an unfair advantage to the defense, if of course they are avoiding or evading. But in case the defense or the client or the accused in that case is in jail, then that also may result into miscarriage of justice. Not on account of any party's fault, not on account of the fault of any stakeholder, but primarily on account because the original records were taken. I have, my review or my suggestion could perhaps be is the digitization of every record, so that, and sharing the entire record of the case file through one-click system, so that it eliminates the need to physically carry the files and place them. B, it stores all the documents and the complete record of the case. Third, it will never be kept in any malkhana or record room, which is prone to so many things such as termites, fire, so on and so forth, right? And fourth, it becomes very, very effective to carry out the trial while at the same time a superior court is examining the case records on their, taking their own sweet time. I think these are some of those aspects which would ensure that criminal trial is carried out in a manner which eliminates undue procedural delays, right? I will be very happy to take questions, because I think I don't wish to exceed my time limit. Thanks.
Thanks a lot for those were really great points to put forward. And I wish the government was as vigilant as you, the points that you made forward. And in fact, very rarely we see in any government, the central government, state government, making these amendments on procedural laws to fasten the process. And it often comes from the courts whenever we see that it comes up either in terms of guidelines or comments. I remember one funny instance from Delhi High Court. I think I don't recall who said it, but it was a criminal matter only, and the government officials were taking lots of time to file certain records before the court, and the judge was like, "I will lock you in the room and unless until you find that file and come to court with that file, you're not coming out of that room." And that's how long it has been. And all the parties, and for quite a few hearings, the matter was stuck because there was no filing from the government side. And it was not that they had to look for something, it was already there in the record. They had just to just get the file and submit it before the court. So with regard to this, I have one question that, we have seen certain guidelines from this, the courts, Supreme Court, to fasten this process, but we rarely see something from the government, central government, or state government. So will you say that the courts should involve more in the process to set up, more strict guidelines to, let's say, to the police, that they should try to, get their can we get investigation done within a certain fixed time period, or will it be better if it comes from the executive or the parliament?
Those kind of directions, you can take it from me, Ashwini, are passed on a monthly basis in the courts, right? In individual cases or general directions. In fact, in one of the matters, I distinctly remember that the High Court of Madhya Pradesh had directed a copy of the order to be placed before the DGP to take appropriate action in this regard against erring police officers, etc. Right? But uh, let's face it, I think there is an inherent tendency to delay the matter, and that could be not that could either be by default or by design. And unless and until there is a manifest intention to take the matter to its logical conclusion, the problem will persist. Unless and until you take one person and set an example, it will perhaps be replicated by others. I've seen that in many courts, the judges have taken the erring officers to task. And of course, it may give them a certain kind of name that this is a very strict judge or a very, go by the book kind of a person. But that's necessary. If you have to conduct a criminal trial, then you have to conduct that criminal trial. And if any of the three parties or stakeholders, which is the defense counsel, the prosecution, or the police officer, do not or resolve that they don't want to participate, then they will find ways and means to circumvent the system. Right?
Oh, if any of the attendees have any questions, please feel free to unmute yourself, or you can also put your question in the comment box. We are still waiting for any question from the audience side. There is one question here. What do you think is the solution to the misuse of Section 498?
Can't say I'm not surprised with the question. Uh, right. Misuse of Section 498. Well, one thing that I often see is that if the guidelines which were laid down in Anish Kumar's judgment are strictly followed, right? Which is to say that A, no omnibus allegations must be allowed. B, the police must register an FIR if they find that cruelty has been meted out and every individual's role has been clearly laid down. And no vague allegations that I was ill-treated, I was tortured by 20 people. No, please mention the date, please mention the time, please mention the specific act of cruelty which was meted against that person. Right? So that must be followed. Second thing, which I believe is of utmost importance, is a section 41A notice must be given to enforce the presence instead of arresting the accused people. Because what happens is, and there's been a growing trend, that the conviction rate under section 498 is one of the least conviction rates amongst other offenses. And one of the reasons of a very low conviction rate is primarily the fact that upon examination of the charge sheet, it appears that there were, while cruelty was meted out by two or three individuals, the names of entire families have been included in it. Say people who are not even residing with the at the matrimonial house, people who are distant relatives residing in different places, right? I think to counter that, what can also happen is that a specific statement must be taken from the prosecutrix towards the end, that these are the individuals and these are the only individuals who have committed that offense. right? I think that sort of a declaration will help. And naturally, if there is any allegation which you feel is, is or which upon investigation is found out that a wrongful information or wrongful initiation of criminal proceedings was in fact carried out, then the court must initiate proceedings under section 211 and 209 of CRPC against the erring person, right? And these are very unused provisions in law, but these provisions are very, very effective, and I think they will prove to be a deterrence for any cases of misuse of section 498, so that even the accused or a person who was wrongfully accused of an offense will have some remedy against the complainant, right? Thanks.
There are two more questions in the comment box.
While Sakshi, I would choose not to comment on the specific case because it is currently sub judice before the court. But I can tell you about generally why certain matters are not treated as a precedent is primarily because couple of matters may involve questions which will have a significant bearing on on the rights of investigation or the rights of individuals. For example, there was a specific judgment which was passed by the High Court. I think it was Guwahati High Court. Yes, where the Guwahati High Court had taken away the power, which said that the formulation of CBI itself is unconstitutional, right? And therefore, various individuals who were languishing in prison started filing bail applications to get out. Since CBI is unconstitutional, therefore, anything that CBI does also, or any action taken also, is rendered illegal, right? And therefore, the Supreme Court immediately, CBI went in appeal before the Supreme Court, and the Supreme Court stayed the judgment of the Guwahati High Court, right? And said that it must not be, while we are analyzing the judgment, it must not be used as a precedent to sort of get out of the rigors of criminal law, right? Next. So Sharika, or is this Tara? I think it's Tara's question. Uh, See, I think you are absolutely right. The remand orders have to ensure that A, they are not passed in a very mechanical manner. B, they must identify the person. Uh, the person, of course, while the criminal law entails that at that stage, the person, there is no requirement in law to hear the person, right? But there are two judgments that uh, can come to the aid of that person. A, if they have stellar and unimpeachable quality of evidence to show immediately at that stage that they are not liable for the commission of the offense, then they can always move a quashing petition and take repose of the judgment. I think it's 2013 TSCC 330. It's called Romesh Thapar versus State of Bihar or Union of India, one of those. It's by Justice Keher. And what the and what can also be done in such cases is that an order where mechanical remand is being ordered, uh, what must be recorded in the order of remand would be A, the state of physical fitness, second, the subjective satisfaction that the person was not subjected to cruelty inside the police custody, right? If these two elements are satisfied, then I think the court must consider the possibility of remand, because see, sending somebody for police remand or judicial remand is the prerogative of the court, and the law requires that for the purpose of initial investigation, this is a sine qua non, but it also has to be made on a specific request, which is of course the application for remand, that judicial custody or or the personal presence of the accused is necessary for the purposes of remand. And since it's for the purpose of interrogation or whatever measure it is, uh, then the court must also record its individual satisfaction that yes, there is a need for taking physical custody of the person, and only those limited category of cases should remand orders be allowed. Now, if there is a problem in the remand orders, then you always have your remedies challenging those remand orders before superior court. I hope that helps. But as a good practice, as a best practice, at least those three components that I have mentioned must feature in every remand order.
So there's one more question in the comment box.
Yeah.
Uh, it's can you elaborate on the statutory bar in 43D UAPU?
Well, there are two things that Section 43D does, which is it modifies certain provisions of CRPC. The first modification that 43D says is that every offense under the Unlawful Activities Prevention Act shall be deemed to be a cognizable. The CRPC makes a distinction between what is cognizable and non-cognizable, and it also understands that while some offenses may be cognizable, there are those offenses which can be non-cognizable. For the purposes of UAPA, every offense which has been committed is a cognizable offense naturally because it's a terrorist act or being an accessory to terrorist activities, all of which will sort of fall within that ambit, right? Second, I think, is they have also modified what is called the time limit which has been provided under Section 167 CRPC, which is that charge sheet must be filed within a period of say 15 days or 60 days or 90 days. All of that has been increased from to 30 days, 90 days, and 90 days respectively, right? Um, and now what happens is that while under 167 there is something which you call default bail, right? So that if the charge sheet is not filed within a period of say 90 days, then a person is entitled to get out on bail. Here there is a proviso which has been added which clearly says that if within a period of 90, despite the period of 90 days being expired, a person has not been, the charge sheet was unable to be filed, then the public prosecutor must make a specific request for the purpose of investigation for police custody of the person, so as to find out or dig out more information from that person. So in such cases where normal rule of police custody of 15 days, etc., is followed in regular offences under CRPC, for the purpose of UAPA, even after a period of 90 days, a further police custody can be demanded by the public prosecutor, but it does not mean that whatever the public prosecutor says has to be accepted by the court. The court has to apply its own judicial wisdom after hearing both parties. Then and only then the court will decide whether there is actually a need to allow for a further period of custody or not. There are, but there are so many changes that are there, and one specific change which I think which sort of uh, is problematic for many human rights activists is the elimination of section 438 right, which is the right to take anticipatory. Now under section 43D subclause 4, a person cannot avail the right to get out on bail under section 438. In such cases, what people have been usually doing is to follow the Uttar Pradesh model. In Uttar Pradesh, there was no section 438 for the longest time. So people used to file criminal writ petitions with a prayer seeking stay of arrest. And I think while a statutory embargo is imposed on a trial court, nothing prevents constitutional courts from exercising powers under 226 of the Constitution of India to grant that relief of anticipatory bail. Has it been done in the past? Yes. Can it be exercised? Yes. So the embargo which is contained in subclause 4 of section 43D will not apply to constitutional courts. That's my understanding of it. Subclause 5 is another problem, which says that usually during the submission of charge sheet, a person is released on bail or bond by preferring regular bail application. That right also has been taken away under section 43D subclause 5. But like I said, nothing prevents the courts under article 226 to grant the same relief, right? Yes, one may want to say that this has effectively taken away the powers under section 437, which is vested with a magistrate, but in this case, since it is exclusively tribal by a special judge, a sessions court, therefore powers under section 439 also have been taken away, which is true. But those powers can always be exercised by a superior judicial forum such as the High Court. It of course results into depriving the accused the valuable right to file such an application before the trial court. Effectively takes away one stage of remedy. But that's what the law says, unless and until of course it is set aside or declared unconstitutional. Next question now.
So there's one more question: is if the higher courts are able to set guidelines like Fishaka guidelines, then why can't there be guidelines for the police be made to ensure that the investigation is proper?
You'd be surprised. There's a case called Prakash Singh's case, in which various guidelines have been passed. Uh, that case is called popularly referred to as police reforms cases. There are many aspects touching upon not just the recruitment and conditions of service, but the mode and manner in which investigation is to be carried out, the the ways in which you could give additional protection to officers on the line of duty, and other procedural safeguards that the officers must bear in mind have always been passed, uh, have been or are being passed from time to time. Yeah, but very often that is not possible because see, you cannot pass general guidelines because every offense would involve a different investigation process. An offense under NDPS Act cannot be tried in the same fashion as a murder case. A murder case cannot be investigated in the same fashion as a rape case. And therefore, you can't have an omnibus 142 guidelines for everything under the sun, right? But yes, for special offenses, there have always been different types of guidelines which have been issued. Yeah, I hope that uh, clears a couple of doubts.
I've also posted a link to the judgment, so it was referring to Prakash Singh's review of India. It's there in the comment box. If anyone wants to access the judgment, they can. Any other question from the attendees? You can also mute yourself and ask your question if it, you know. I do not see any question coming in chat box or Thanks a lot for joining us for the session, sir. And it was just really great sessions, and I learned quite a few things from the sessions. And there were a couple of good questions from the attendees as well. So thank you for asking those questions. The case, so it was just so just refer to Prakash Institute of India is a really great case to look at. So if you're looking into something on police reforms, it's a must case that you should look into. Do check it out. And thanks again for joining us for the webinar, sir. And thank you, to all the to everyone in the audience for staying with us for almost an hour. And thanks a lot. Please do subscribe to our criminal review if you want to receive any updates on upcoming events, or to receive any updates on blog or newsletter. And yeah, that would be all. Thanks again, sir. Thank you.
Thank you so much, Ashwini, for having me. Thank you so much, everybody, for being so very patient. Thanks.
I will be ending the meeting in a few seconds. Thank you, everyone. Bye-bye.